If you have employees in California, understanding time off is not just a policy decision. It is a compliance requirement that can impact your payroll, your employee experience, and ultimately your risk as a business owner. Welcome to Biz Help for You, where passionate support and practical guidance help your business thrive. What makes time off rules especially challenging is that California does not operate with just one type of leave. There are multiple layers. Some are employer paid, some are state funded, some protect income, and others protect the employee's job. Many of you may not be located in California, but if you have just one employee working remotely and living there, this will apply to you. So tune in to understand what you must do to be in compliance and avoid costly penalties for failing to grant the appropriate time off. In today's episode, I'm walking you through the different types of time off available to California employees. We're going to start with mandatory paid sick leave, break down how it works, including accrual versus upfront policies, and then build from there into disability, paid family leave, workers' compensation, and job-protected leave under CFRA. Along the way, I'm also going to address some of the most common areas where business owners get confused, because that is usually where the problems begin. Let's start with the one that applies to most employers. Paid sick leave, often referred to as PSL. As of January 1st, 2024, employers must provide at least 40 hours or 5 days of paid sick leave per year to eligible employees. Now, most employees are eligible if they've worked for you for at least 30 days within a year in California. However, they can be prevented from using the sick leave until they've completed 90 days of employment. That distinction matters. They begin earning the leave right away, but they cannot use it immediately. Now, let's talk about how that leave is provided, because this is where a lot of employers make decisions that impact their payroll setup. There are two primary ways to provide sick leave. The first option is the granted or the front-loaded method. This means you provide the full amount, typically 40 hours, all at once, the beginning of the year or the start of the employment. This is the simpler option from an administrative standpoint. There's no need to track accrual throughout the year. The employee has access to the full balance once they're eligible to use it. The second option is the accrual method. With accrual, employees earn sick leave over time. The minimum requirement in California is that employees must earn at least 1 hour of paid sick leave for every 30 hours worked. So if you have an employee working 30 hours, they earn 1 hour of sick leave. If they work 60 hours, they earn 2 hours, and so on. Now, here's where a common question comes up. Do you have to allow unlimited accrual? The answer is no. You can place a cap on how much sick leave an employee can use in a year, typically 40 hours, and also limit how much can be carried over. However, those caps must be structured correctly to remain compliant. This is one of those areas where payroll systems really matters. If your system is not tracking accrual correctly, you may not even realize you're out of compliance until there's a problem. Another area that often surprises employers is how broad the use of paid sick leave really is. This is not limited to someone calling in sick. Employees can use paid sick leave for their own physical or mental health. That includes illness, injury, diagnosis, treatment, and preventative care. They can also use it to care for a family member. And California defines family broadly. This can include children, parents, spouses, registered domestic partners, grandparents, grandchildren, and siblings. In addition, employees may be able to designate a person for care in certain situations. So when an employee requests to use sick leave, it is important to understand that you cannot narrowly define what qualifies. A question I hear frequently is whether an employer can ask for a doctor's note. The answer is you need to be careful. While you can have reasonable policies, overly strict documentation requirements can conflict with California law, especially for shorter absences. The focus should be on compliance and consistency, not creating barriers for employees to use the leave they're entitled to. However, this is where your internal policies can still play an appropriate role. If your employee handbook includes a reasonable requirement, such as providing a doctor's release after missing a certain number of consecutive workdays, you are generally allowed to follow that policy. For example, if an employee is out for multiple days and your policy requires medical clearance before returning to work, you can request that documentation. The key is that your policy is applied consistently and does not interfere with the employee's right to use their paid sick leave. Now let's clarify something important. Paid sick leave is not the same as vacation. California does not require you to provide vacation at all. However, if you do offer vacation, it becomes earned wages and must be handled very differently. I'm not covering vacation in this episode. If you have specific questions on how to handle vacation pay, send me a message at media@abandp.com. Paid sick leave also does not replace disability insurance or job-protected leave. It is just one piece of a much larger framework. Now let's shift into another category. Let's start with workers' compensation, because this is one of the most important distinctions to understand. Workers' compensation applies specifically to work-related injuries or illnesses. If an employee gets hurt on the job, develops a condition because of their work, or even aggravates an existing condition due to their job duties, this is where workers' compensation comes into play. In California, if you have even one employee, you are required to carry workers' compensation insurance. It's not optional. What workers' compensation provides is much more comprehensive than paid sick leave. It can cover medical treatment related to the injury, partial wage replacement while the employee is unable to work, disability benefits if the injury has longer-term effects, and even return to work support or job retraining in some cases. Now, here's where I see confusion happen. If an employee has a work-related injury, you do not just direct them to use paid sick leave. There is a formal claims process that needs to be followed, and timing matters. The employee should report the injury as soon as possible, and you as the employer are responsible for providing the appropriate claim forms and next steps. Another question that often comes up is whether employees can use paid sick leave at the same time as workers' compensation. In some cases, yes, sick leave may be used to supplement benefits, but these are separate systems with different rules. They should not be treated as interchangeable. The key takeaway here is that when something is work-related, it shifts into a completely different category with its own compliance requirements. You'll need to follow the process for submitting injury information per your provider's specific guidelines. Now let's move into state disability insurance, or SDI. This applies when an employee is unable to work due to a non-work-related illness, injury, or medical condition. This is an important distinction from workers' compensation. If it did not happen because of the job, SDI is likely the program that applies. SDI is funded through employee payroll deductions. As the employer, your role is to ensure those deductions are being withheld and reported correctly through payroll. If an employee qualifies, SDI provides partial wage replacement, typically around 60 to 70% of their regular wages for up to 52 weeks. This can apply to a wide range of situations. It could be a surgery, a serious illness, pregnancy-related disability, or even recovery from a medical condition that temporarily prevents them from working. Now, here's the key point that often gets missed. SDI does not provide job protection. So while the employee may be receiving income, that alone does not guarantee their job will be there when they return. That is where other laws like CFRA may need to come into play. From an employee perspective, one of the biggest responsibilities here is communication and coordination. Employees often do not fully understand how to apply, what documentation is needed, or how this interacts with their leave from work. Paid family leave builds on SDI, but it serves different purposes. While SDI is for the employee's own medical condition, paid family leave is for what the employee needs time off to care for someone else or to bond with a new child. This includes caring for a seriously ill family member or bonding with a newborn, adopted child, or foster child. Like SDI, paid family leave is funded through employee payroll deductions and provides partial wage replacement, typically in that amount, again, the same 60 to 70% range. The benefit is shorter, up to 8 weeks. Now, here's another important distinction. Paid family leave, just like SDI, does not provide job protection. So if an employee is taking time off to care for a family member, the income may be covered through PFL, but whether their job is protected depends on whether they qualify under laws like CFRA. This is where you need to be very careful not to assume that pay and job protection automatically go together. They are often coming from different programs. If you have an employee on paid family leave, you need to understand whether another law like CFRA is also applying to protect their position. So this brings up one of the most important pieces of the puzzle. The California Family Rights Act, or CFRA, provides job protected leave. The California Family Rights Act has the job protected leave, which means that the employee has the right to return to the same or a comparable position after their leave ends. Eligible employees can take up to 12 weeks of leave in a 12-month period for their own serious health condition or to care for a family member. To qualify, the employee must have been with you for at least 1 year, worked at least 1,250 hours in the past year, and you must have at least 5 employees. CFRA also requires that you continue the employee's health benefits during their leave under the same terms as if they were still working. Now, again, this is where employers have questions about timing and overlap. CFRA can run at the same time as SDI or paid family leave. So an employee might be receiving income through one program while their job is being protected under another. Another question that comes up is whether CFRA has to be taken all at once. The answer is no. In many cases, it can be taken intermittently, depending on the situation. That adds another layer of complexity for tracking and payroll. There's also an important mindset shift here. CFRA is not about paying the employee, it's about protecting their position and ensuring compliance with leave laws. Now let's bring this all together, because this is where it really starts to make sense. These programs are not meant to stand alone. They are designed to work together. An employee might start by using paid sick leave for a short-term illness. If the condition becomes more serious, they may apply for state disability insurance to replace a portion of their income. At the same time, they may qualify for CFRA, which protects their job while they're out. So you have one program providing pay and another protecting their position. This layering is where you need to be very intentional. Let's say an employee has a non-work related injury and cannot work for 6 weeks. They might first use their paid sick leave, then transition to SDI for income, and then request CFRA leave to ensure their job is protected. If these are not coordinated correctly, it can create confusion, payroll errors, or even compliance issues. There are patterns I see repeatedly when I step into payroll cleanup situations. One is not tracking sick leave accrual properly, especially when employees have varying hours. Another is assuming that offering vacation replaces the requirement for the paid sick leave, which it does not. Your time off policy must meet the minimum number of hours and be the same or more generous than required sick time that the California law says you must offer for you not to have a specific sick time policy. I also see confusion around when job protection applies versus when it does not. And one of the biggest issues is not aligning payroll systems with these requirements, which leads to inaccurate balances, incorrect reporting, or risk for you, the employer. California has built a system that is meant to support employees through different types of life events, from short-term illness to long-term medical leave to caring for family. But for employers, that system requires structure, clarity, and attention to detail. When your policies and payroll are set up correctly, these processes can run smoothly in the background. When they're not, they can quickly become overwhelming. If you have employees in California and you're not completely confident that your payroll system is tracking sick leave correctly, handling accruals properly, or supporting these different types of leave the way it should, this is something worth addressing now. Affordable bookkeeping and payroll services can work with you to take payroll off your plate, ensure compliance, and create systems that actually support your business. If you need help with payroll processing or you want to review your current setup, I invite you to reach out to us at 310-534-5577 or contact@abandp.com. It's always better to get this right on the front end than to fix it after there's an issue. Thank you for tuning into this episode. I hope you found this explanation helpful so that you can understand the different types of time off available to your employees and when they apply based on their specific scenario that the employee is experiencing. If you have additional questions, I've created a free guide to assist you. Reach out to us at media@abandp.com to request this to be sent to you. Thank you for tuning in today. Would you please share this episode with those you know and leave a review on your favorite platform? And if you find our show informative, would you consider being a financial sponsor to help me continue my mission to educate business owners? A link is located in the episode description, and no amount is too small. I'd really appreciate your support. If you are interested in connecting with our guest and receiving the offer they had to share, a link to our resource page is in the show notes. Finally, if you have any bookkeeping or payroll needs, reach out to us at 310-534-5577 or contact@abandp.com. My team and I are eager to assist you. Until next time, have a great day.
Thank you for listening to Biz Help for You. Please join your host, Candy Messer, again next time. Have a terrific day.